The skit you just saw concerns mistake. Now, let's ignore the obvious fact that the three actors in the skit obviously are people without capacity. Let's assume that Paul, Daniel, and Laura are all adults. If they were, in fact, lacking in capacity, any one of them as a child could void the contract. It would be a voidable agreement. But assuming that all the parties have capacity, the issue really involves mutuality of assent. And three of the four main categories in mutuality of assent are not really present. The elements necessary for fraud, for undue influence, for duress, do not appear, based on the fact pattern in the skit, to be present. So the focus really should be on what? On mistake. And the mistake present in this scenario is a unilateral mistake. It's a mistake on the part of the seller through its agent, Paul, to know what the real value of the Babe Ruth card should be. To get confused as to whether it's really $10 and there's a decimal point there, or whether it's in fact $1,000. Unilateral mistake is only actionable by the mistaken party, in this case the shop, if the non-mistaken party, in this case Laura, the card shark, in honor of her I'm brought in various accoutrements, a boa to symbolize living in the lap of luxury, all sorts of silvery, shiny, sequined hats. Also took a New York Yankees shirt in honor of Babe Ruth. But what we've got there with Laura is we've got a person who got a good deal, very, very good deal. Now, if she is equally innocent of the mistake that is made by Paul on behalf of the shop, then she gets to take the contract the way it was entered into by the parties. Between an innocent and a fool, the law tends to side with the innocent. Between an innocent and a crook, the law will decide on behalf of the innocent or the fool. So even though Paul is foolish, if somehow the shop could prove that Laura actually knew about the mistake, actually knew that something about this old guy named Babe Ruth, and knew that he actually was a great baseball player and his cards were worth an incredible amount, then the shop owner should be able to go after Laura and try to get either the card or some sort of damage award from Laura. Now, you might be saying, in effect, well, how can you prove that somebody knows something? I mean, that's just probing into their mind. It isn't that very difficult. They're just going to deny it. Well, if you have circumstantial evidence, if you have extrinsic factors that can be proven, such as receipts showing she's bought lots of other baseball cards, if you subpoenaed her records and showed that she had an extensive baseball collection, if you put her on the stand in a deposition and forced her to answer certain questions, you might be able to show that she knew enough that she must have known about the mistake by Paul. So let me go through a scenario, a pretrial deposition, to show you how this might work. The shop, through its attorney, is proceeding against little Laura. And when I'm Laura, I'll put on the cute little Daisy Duck hat. Okay, Laura, how many cards do you have in your collection?
Thousands.
Do you have any old cards in your collection?
Yes.
Do you have any cards from the 1930s in your collection?
Yes.
Why do you collect?
It's fun. It's my hobby.
Do you think your cards might be worth some money in the future?
Yes.
Why do you think that?
My daddy says baseball cards are a good investment. He says maybe my cards will pay for college.
Do you know what your cards are worth now?
Sort of.
How do you know?
I looked them up in Beckett Baseball Card Magazine.
Which ones are worth the most?
Star players and the older cards, especially the rookie cards of the stars.
Okay. perhaps the deposition would not go quite so smoothly. But you can see, if you've got some extrinsic evidence, if you've got testimony from other people who know Laura, if you're able to get certain things ahead of time, you can put this person in a position where they probably have to acknowledge that they know or must know or should know certain things. And if you can put them in that position, such as in this case, if you can put Laura in the position where she acknowledges that she knows this card is from the 1930s, she collects a lot of cards from the 1930s, that she knows the cards can serve as an investment, that she keeps track of the card's worth through Beckett's baseball magazine. If you've got all of that, I think it's a natural, easy step to then say, Laura must have known that the card she was getting at the shop was worth much, much, much more than the $10 that she was being asked to pay, and that she is taking advantage, in effect, then, of a unilateral mistake by Paul. At worst, if we could demonstrate that she had actually overheard some of the early conversation between Paul and the store owner Daniel before Daniel left, we might even be able to prove that she knew directly, just from the circumstances, that Paul was a fool about baseball cards, didn't know anything about them. But even if she had not overheard that conversation, even if she knew nothing about Paul and Daniel before she actually stepped up there and tried to buy the card, the fact that we know she's a collector, she knows about the investment qualities of these cards, etc., should be enough that we can show she is not an innocent. She's certainly no fool. She is, in fact, probably behaving in a rather crooked fashion. Now, what's interesting to note in this whole area is, while Laura's title to the card would, if she's taking advantage of a unilateral mistake, be voidable title that could easily be taken away from her by the shop owner in a lawsuit, that title can nonetheless expand, grow, become more significant, if you will, if she passes the card on to a good faith purchaser. So, even though Laura, if in fact she is a crook, if in fact she knows about the value of the card, if she is a card shark, would be forced to disgorge the card, return it to the shop owner, and just get her measly $10 back, if she sold it for a fair market value to an innocent third party. Let's say she meets somebody at the bus station. There she is with her boa, and she sells the card for $950. And its fair market value is about $1,000. So there's a slight discount, but it's within the range that we would assume this is a good faith purchaser. He has no reason to know about the transaction Laura had with Paul. He buys it for $950. He now has good title. Even though Laura's title was voidable, his title is now good title. Does that mean that the shop is without any remedy against Laura? No. It simply means they can't get the card back necessarily, but they can go after Laura and seek damages. They'll get a damages award, but they really won't have any claim against the third party who innocently paid good value for the card. This is an interesting question nowadays with roadshow antiques there on television and things being sold on the internet and all sorts of other things in terms of what is the knowledge base of the sellers, of the buyers, what should they know? And we're getting into more and more questions of, is there a mistake? Is it a mistake the other side knows about? Can people withdraw from a contract because the other side took advantage of a mistake? The old-fashioned principle is, unless you can show the other side knew about the mistake, you're probably stuck with the objective contract you entered into, even though you really have done yourself in by, say, selling a Babe Ruth baseball card for only $10. But it's an interesting area of the law. I'll point out that if any of you are Civil War buffs, there was a general for the South named Pickett, George Pickett. You've heard of Pickett's charge there at Gettysburg. It was probably the high point and low point, really, of the South in terms of the decimation of the rebel soldiers there, the beginning of the end, really, of the Confederacy there on the hills there in Pennsylvania, in Gettysburg. Pickett's descendants sold a number of objects, a number of documents and other things connected to Pickett, and it turns out they sold them to an antique dealer for what turns out to be a very, very low price. And they are now trying to, in effect, either get the objects back or get paid the real value of those objects from the purchaser. And I think the only thing that gives the Pickett's people perhaps a pretty good case is the fact they were dealing with a collector, they were dealing with an expert in this field. If they were dealing with a raw, rank amateur and knew it, then they would have no reason to suspect this guy was an expert in this area, and both sides are really going in blind and unable to complain afterwards about which side got a better deal. But when you're dealing with someone who's more of an expert, when you're dealing with a card shark, later on you can use that against them, if you will, to demonstrate they were taking advantage of your foolishness. Yes, you were a fool, but they were not innocent. They were crooks. And the last thing to note is, what if Laura, instead of bamboozling or swindling Paul at the card shop, had just stolen the card? What if she stole the card? Well, this is an area where, according to U.S. law, not necessarily European or other countries' laws, but U.S. law, theft can never pass good title on to anyone. Now, if you defraud someone or you otherwise obtain a card under false pretenses, you may have voidable title, yet you pass on good title to people down the line. With a theft, the thief does not get good title, and the thief can never pass on good title to the after acquirers. This is an interesting point with respect to, for instance, art that was stolen by the Nazis back during World War II, and there are claims being brought presently with respect to museums and others that have acquired the art, that paid money for the art, that may claim to be good faith purchasers, and yet under U.S. law, if people can trace the art back to an actual theft, stealing by the Nazis, and can prove that they or their ancestors owned the property before the Nazis stole it, then they are the rightful owners, and in effect, they can go into court and under U.S. law get those paintings, that other artwork, back from the museum. The only claim the museum would have as a good faith purchaser is from the people that it dealt with. The persons that ultimately would get stuck, if you could go back down the chain, would obviously be the Nazis, and after the Nazis it would be whom? The people that dealt directly with the Nazis. But you'd have to go back, each person would go back to the one before and say, you breached your warranty of title, in effect, by selling me stolen goods. The persons from whom it was actually stolen, they are the ones that always will have the true title under U.S. law. Okay, that's it for the card shark. Watch out for people dressed like this. They're up to no good. And what you have to hope for is that you don't engage in any mistaken behavior. If you do, hopefully you can prove that these people were crooks, not innocents.